When Marilyn asked me not to show my slideshow, I assumed it was because she was getting bored of it or didn't think it was very impressive. But now she tells me it's because the Law Society charges 400 quid to use the projector. Maybe you're just trying to be diplomatic and not to offend me, but anyhow, you'll just have to listen to me talking very briefly about the current state of play in claims in the UK against UK multinationals, which are cases that we've been running now at Leigh for about the last 20 years, and over which time there have been very significant developments, mainly positive, but some not so positive too. So these are negligence cases, damages cases, in which it is alleged that there has been a breach of a duty of care owed by the company. These are not cases which allege violations of human rights, but the subject matter of the cases very much is human rights. And I certainly take Robert's point that expressed in that way, an injury is not the right way, or a trespass to the person significantly diminishes an offence like rape. But of course, when these cases are litigated, the facts do come out, and whatever you call it, it will be plain to see what has actually happened. So, for instance, in the Monte Rico case, they were cases which were brought in negligence and under the Peruvian Civil Code, but did involve very clearly allegations of sexual abuse. Just going back to basics for a moment, multinational structure, as we know, you have parent companies, usually based in developed countries, and local operating subsidiary companies, which ostensibly are the ones that carry out the operations. Corporate veil problem, and this is the slide that Robert was talking about, is the problem of limited liability, the concept that as a shareholder in the subsidiaries, a parent company is not usually liable. And the way in which we have approached this, really from the outset, was rather than looking at the position from a shareholding perspective, is to see whether it is possible to impose a legal duty of care on the parent company. And what that depends on, factually, is looking at the functions that a parent company was responsible for within a multinational group, and seeing whether those functions, or deficiencies in those functions for which the parent company is responsible, can be connected with the harm that has occurred on the ground. In the Thor Chemicals case, for instance, we focused on the role of the parent company in designing the technology deficiencies in which caused workers in South Africa to be exposed to high levels of mercury. In the Cape PLC case, it was about the role of the parent company in controlling the health and safety system. In the Anglo-American case, on behalf of South African gold miners, again, it's about the role of the parent company in dealing with medical protection and dust control. At least that's the allegation. And through that series of cases, the notion of a parent company duty of care has gained increasing traction. And finally, that led in the Chandler case, which was a case against Cape PLC for a worker at a UK subsidiary of Cape PLC, led to the acceptance by the Court of Appeal that, in principle, provided certain criteria were met, a parent company could owe a legal duty of care. Now, that's the position in English law. In these cases where we're dealing with harm that has occurred overseas, because of a provision of the Rome II regulation, a provision of European law, we have to generally apply the local law. So the English law position doesn't determine directly the outcome in these multinational cases, but when you're dealing with countries whose system of law is based on English law, then the outcome is likely to be the same. And even in other cases, for instance, the Monte Rico case where we were looking at the Peruvian civil code, you find that even though the system is different, that they do generally have the same kinds of legal provisions. The duty of care issue sounds like a difficult one to overcome, but in practice, what we have found is that it's not one that the defendants want to confront that aggressively. It's not usually the main problem in these cases. It sounds like a great challenge, and obviously before you embark on this kind of case, you need to be able to identify certain actions or omissions on the part of the parent which you can connect with the harm, but provided you've got some basis for those allegations, it's not usually the issue that causes the problems. Now, just very briefly, some of the challenges so these are the positive things. So over the last 20 years, we've seen very positive developments in terms of jurisdiction, no more forum non-conveniens, and also increasing acceptance of the possibility of a duty of care owed by a parent. On the other hand, we've had some setbacks. The what's called the LASPO bill, the Legal Aid Sentencing and the rest of it. Anyway, LASPO. That dealt with changes to the civil costs regime and introduced much tighter principles around proportionality. So the idea that in order that the expense incurred in running cases should be proportionate to the value of the cases. And that's quite a significant issue, because clearly cases like this are incredibly expensive to run. They're fought tooth and nail by the defendants, and they're extremely complicated cases, and even if you have a small number of claimants, the costs are still often much higher than the damages in the cases, or value of the case, especially since, in view of this Rome II regulation, which you've heard about, the damages are now assessed by reference to local levels of damages. So the effect of Rome II is to reduce the levels of damages, which used to be English levels of damages. And at the same time now, you've got this proportionality principle, which is telling you you shouldn't be incurring costs which are in excess of the damages. So these two factors together, the combination of these two factors, does make running these cases less financially viable for the lawyers who are running them. And I suppose is of particular concern where in cases where you have relatively small numbers of claimants, where the total amount of damages is going to be relatively small, where you've got a mass tort claim, then collectively the damages will be much higher and the proportionality principle is easier to satisfy. So just to summarize then, over the last 20 years, in general, very positive developments, certainly compared to 20 years ago. I remember the first time we went to court in the Thor Chemicals case in 1994, and the judge saying, "What are all these South Africans doing in this court?" Well, no one would say that now. It's certainly a type of an area of litigation which has gained increasing acceptance. But there are nevertheless constantly new challenges arising that we have to deal with.